Hello everyone and welcome to Sambhav Law. I welcome you to this session which we are having with Mr. Abhishek. He has scored All India rank 14 in the CLAT PG 2022 paper. So accordingly, firstly, Abhishek, I welcome you to the channel.
Thank you for having me, sir. Thank you.
Yeah. So firstly, can you, Abhishek, can you introduce yourself for the audience?
Yes. I am Abhishek Maitra. I completed my BA LLB from KIIT School of Law, Bhubaneswar, and I appeared for the CLAT post-graduation examination in the year 2022.
Yeah. So accordingly, Abhishek, firstly, can you start with the question that when you started your preparation, what was your motivation behind starting it, and when did you start with the preparation? What was going in your mind? How did you start everything?
Yeah. So I knew that I had to opt for this line. I think in the beginning of my fourth year, I knew that I had to pursue my master's, and I knew that at that time when the pandemic had struck in, there was a change in the pattern in the year 2020. So I think I devoted a lot of time in understanding what the new pattern was, firstly before starting with my preparation. So I think I had a comprehensive look into the 2020 paper and what it is trying to address, what areas and nuances of the laws and analysis it wants to ask. So I think firstly the clarity over what the consortium is trying to ask is important before the preparation model begins. And I think that from that time I started understanding what the consortium wants to test, how is it testing your analysis, and that was strengthened with the 2021 paper which had happened in the month of July. And post that, I think since my final year in bits and pieces, I started to prepare for this examination.
So Abhishek, so like when you started with your preparation, so when you started, it was like 6 months ago, right?
Yeah, it was six to 7 months ago. Yeah.
So when you started with that, so like what was your approach? Did you follow some sort of a strategy, or like what books were you referring? How did you study the cases, everything? Can you just give a brief glimpse for that?
Yeah, so my analysis into the 2020 and 21 paper was clear, and it made it abundantly clear that the paper revolves around few subjects, and specifically few subjects which have been highlighted by everyone are constitutional law, criminal law, certain parts of international law, family law, etc., etc. So I knew that I did not want to be someone who wants to score every question in the question paper, but my objective has to be to score the maximum number of questions with the least negative marking. And therefore the preparation starts with the objective that how can you transform this preparation with the fact with your semesters and everything. So I knew that I was pretty decent with my constitutional law, and I knew that the consortium is not generally asking questions based on schedules or which articles are being asked, barring one or two questions. So I knew that the certain parts which I need to be clear was fundamental right, DPSP, emergency provisions, and other landmark provisions with reference to the amendments. So you can read any bare book of constitution, be it J.N. Pandey, be it V.N. Shukla, but the objective is to prepare everything very concisely. You cannot go into read 50 pages of a particular article or a concept, because that will be completely vain. So I think when the division of those topics and the important ones, and then looking into important jurisprudence which has developed over the 5 years, starting from 2017-18. So be it the privacy judgment, be it I had also prepared the marital rape issue with reference to the Delhi High Court judgment. So I think there has to be a blend of both your judgment and both these provisions of the law to make an impactful effort in the examination.
Yeah, definitely. So accordingly, Abhishek, as you told us that you went for very precise strategies style. So after like when 1 month was left, as you had prepared so much, so in the last 1 month, what was your strategy? Like, did you change anything, or was it pre-decided already?
No, it was very much pre-decided. I think I knew that I had a cutoff date for the month of April. So I knew that I don't want to read something very new unless it's very important after April. So the only thing I had read for the purpose of May in terms of judgment was the sedition law and the jurisprudence behind the sedition law. So I knew that there has to be a time where I have to cut off reading new things and revise my existing things, because then it becomes a conundrum to prepare everything together, because there are multiple subjects. So the focus in the last 1 month was still on the major subjects and the amendments and the revision of the landmark judgment and the constitution bench judgment, and statutes, let's say the Indian Contract Act and the Hindu Marriage Act, etc. So there was nothing new, but a proper synchronized effort of the revision of the existing subjects.
And if I go towards the paper now, so when you saw the paper, once you saw it and everything happened, what was your reaction after seeing the paper?
Yeah, so when the paper was given to us, I could evaluate that the question paper had 36 pages of the total number of pages in the question paper was 36. So I knew that this won't be difficulty level of what had happened in the year 2020. So this would be a blend of what had happened last year in the 2021. So the moment there were 36 pages in the question paper, I knew there are going to be 20 comprehensions. And before I opened my envelope, I had my mind working that I don't need to devote a lot of time to a particular passage at the beginning of the paper. And therefore, I had my areas of the law which I had demarcated, and I firstly focused on them. And that was the objective. And I knew that okay, there are certain tricky parts in the paper which with reference to the juvenile justice law, the Family Courts Act. But I think a slow and steady reading of the passage would at least give you the idea to solve at least 3 or 4 questions out of the 6.
Okay. So if I go towards the approach, when you saw the paper, you told us that 36 pages were there and everything else. So did you divide your approach as to like some sort of a pre-planned strategy? Like you had this in mind that I will go when I go for the paper, I will firstly do the paragraph that I know first, then I will go for the paragraph that I do not know, and how did you manage the time and everything?
Yeah. So because I had given a couple of mocks during my later part of preparation, so I knew that even if for the first 5-10 minutes I don't attempt many questions, I'll be able to cover it up at the later stage. So the first 5 to 7 minutes from my side was a brief analysis of the whole paper and as to what are my strengths. So I had identified the passages on contract law, the passages on jurisprudence, the passages on criminal law as my areas of strength. And I knew that I need to do these passages first and then focus on to the other areas of law which per se might not be my strength, be reference to international law or the juvenile justice law. So therefore, I gave the first 10 minutes in understanding the paper rather than just opening the question booklet and solving the first question at the outset. So I had to calculate what is the amount of attempts I need to make in this examination, what is the amount of time I need to devote to a particular question. So because the question paper was lengthy, but if you read briefly and if you know what to read in the passage and the question, then it wouldn't be a bigger issue to crack this examination. So I gave first 10 minutes to understand the paper rather than solving that.
Okay. So Abhishek, my next question would be that, like, as you know, that the pattern has deviated a bit. So what is your take on it? Like, was the 2022 paper more difficult than a 2021 one, or what's the total approach? What do you think?
I think the 2022 paper, I think, adds quite a few more uncertainties around the paper. I think generally you don't expect questions from areas like Family Courts Act or questions from Juvenile Justice Act, but I think the consortium wants to make sure that you need to be prepared with everything under the sun. So I think the best approach to such a situation is to make sure that whatever you can read in your capacity, keeping aside what the consortium might ask. So I think the 2022 paper was a slight deviation from the 2020 and 21, where it did not ask much on recent judgment, but it asked provisions on particular article numbers with reference to Constitution or the United Nations Convention on Laws of Seas. So I think that was a little deviation. So I think the next batch in the year 2023, I think they need to keep in mind that this is a very unpredictable paper. You might get questions from recent judgment, you might get questions from important judgments, you might get questions from amendments, statutes, etc. So the best holistic manner of preparation is to make sure that you read the judgment in consonance with the statute, and therefore it tries to give you an idea that you might be able to solve, if not all, at least 4 or 5 questions out of the 6 questions. And I think that has to be the strategy, irrespective of the change in this examinations pattern in the year 2020.
So, as I was going to come to the 2023 paper, if you started to prepare for that one. So, if I talk about, if you start to prepare for this paper and if you give your take as to how one should prepare for the 2023 paper. So what about the major subjects like constitution, IPC and CRPC, and what about the minor subjects like company law, tax law and everything else? What would you be your approach to tackle those?
I think my approach would be the same which I had applied in the current year. I think you just because questions from tax law have come d- doesn't mean I'll go and revise and extensively go on to thoroughly read income tax law or the GST law or any other taxation material for that aspect. My priority would still be constitutional law, criminal law, specifically the CRPC and the IPC, and divide within the CRPC as to what is important: the pre-arrest provision, the pre-trial provision, the charge provisions, the arrest provision, the bail provisions. So these are few important things out of the whole code. At least at the beginning, the aspirants should try to cover as their fundamental basis of preparation. Like this time the questions had come directly from the Gautam Navalakha judgment with reference to 167 of the CRPC and etc. So those were very fundamental and statute based questions. So it is not that you have to know everything about any act, but you have to know the most important parts. So arrest, bail, cognizable, non cognizable offense, charge, I think these are the most important things which one has to be aware with reference to their preparation model. And with reference to minor subjects, I think I would still suggest aspirants to take minor subjects at the later part of their preparation. So once you are done with your fundamentals, which include constitutional law, criminal law, family law, international law, certain parts of contract law, etc., once you're done with the major chunk of preparation, then shift yourself to any judgment or concept of arbitration law or juvenile justice law or any other law for the time being. But the focus has to be on those 5 to 6 subjects, because one thing which has been consistent in this last 3 years, questions have come from constitutional law and criminal law at the max. So no one can deny that fact. The nature of the questions, how they have been asked, might be different, but the domain area have been the same. So I think cover firstly the landmark and the important subject, and then shift your focus to the minor subjects.
Minor subjects, definitely. So Abhishek, if I come to the next part, so if I talk about the mock papers, so you also said that you also practice mock papers and everything. What do you think is the importance of mock papers for this exam?
Yeah, very much, because I think the 2021 paper was a deviation from the 2020. 2020 paper had 12 comprehensions, each comprehension having 10 questions, to my knowledge. 2021 comprehension had 2021 paper had 20 comprehensions. So there was a sudden change. So people get worried by looking into the length of the question paper, and there might be chance that it is the trend of the consortium. So there are a couple of things mock paper gives you an advantage irrespective of whatever stage of your preparation you are. Firstly, it gives you an idea of an real time exam based simulation, and I think that real time exam based simulation as to is very important as to how do you control your attempts. You don't want to over attempt question, because at the end this is an OMR based paper. The moment you take anything in the OMR, you cannot rectify from that position. And there are a couple of errors which even I made at this stage in my paper as well. So it's not that I didn't make that mistake, and therefore preparation and with mock papers is fundamental irrespective of the score. Doesn't matter, and people generally think that the score matters. The score doesn't matter. The mock paper gives you the idea as to how you will tackle with comprehensions from various subjects, be it constitutional law, be it criminal law, be it any other important area of law. So that exam based simulation practice is very important along with time management.
Yeah. So if I talk about the next aspect, so if I talk about the judgment themselves, Abhishek. So when I talk about judgment, did you like what do you personally think? Like, do you think that we should go and read ahead the important judgment, the whole judgment while by like opening it SEC online or the PDF, or should be the approach of live law or SEC online blog? What would you say?
Yeah, I think to be honest, I think at the beginning students will have this curiosity to read everything under the sun, but the truth is that they will not be able to gather anything at all. And the problem is that everyone has to keep in mind that what and how much they can read during revision. They cannot read the whole 500-page Puttuswamy judgment during revision. So I think the outset is that I used to see articles and topics revolving around that matter. So I think if it's the sedition law, I used to look into certain normal random Google searches as to what the provision is, why it has been under the issue, and then I used to had a clarity in my mind as to, okay, this is what the whole issue is. There is a restriction on free speech. So when I'm reading the judgment, my focus is exclusively on those parts rather than the whole anecdotes of the judgment. So reading whole judgments is not at all the right approach. Live law, bar and bench, which gives you head notes, are the best method. But on important constitutional law judgments, like this time the Lok Prahari judgment was asked. The Lok Prahari judgment did not only ask the name of the case or the article of the constitution, it also asked the law commission report. It also asked the transfer of judges cases. So all those aspects you will not find in a liner or two. So for certain judgments, like constitutional law, like if it's the Maratha reservation judgment, read it in detail. If it's the sedition law, read it in detail, but not for every law. Classify cases on the basis of public importance, public interest, and then give priority to laws and
Okay.
reading judgments.
Yeah. So, Acha, Abhishek, what is your approach like when a person is preparing for jurisprudence? The jurisprudence is a very burning question. You know how to prepare jurisprudence, and jurisprudence is so big, so difficult. What do I remember? What is your take on that?
I think to be very honest, I think no educator today has an answer to how to cover up jurisprudence for any particular individual as a whole. And I think the best model is that you focus on certain important parts firstly of jurisprudence. So you generally try to cover the schools of jurisprudence, and this time there were the first few questions on jurisprudence were from the schools of law, the legal positivism and the natural laws aspect. I think first prepare the schools of law very briefly as to what the whole school and the what idea is, and then focus on rights and duties and other aspects of the law. Don't generally try to focus too much on which person said what and try to mug that up, because I don't think even if someone tries to do that, they can anyway recall that, because there are 15 definitions of jurisprudence, there are 10 definitions of the rights and duties, etc. So I don't think that would be feasible and logical. And I think aspirants should also understand that they cannot mug up every definition. So for certain definitions, they can just read the important parts. So like if you're reading the definition of Austin under the positive law, just read two words, which is politically sovereign and politically inferior. So the moment you find these two words, you know that okay, the school of law which has been talked in the instant case is the Austinian law or the positivism. So I think that is the right approach for something like jurisprudence, rather than going into too much of who said what and mugging it up, because I don't think you can recall it when the exam starts and when you have the anxiety to solve 120 questions at that 2 hours. I don't think you'll be able to recall everything. So you will find questions like we had this year, who said this, like there was a quote as the answer was Benjamin Cardozo, etc, etc. So you will have one or two questions like this, but as I said, you cannot prepare everything under the sun. The objective is to make sure that you try to prepare the maximum amount you can, with the fact that it is possible for you and not difficult in terms of revision.
Okay. So my next question would be that, like, see, Abhishek, there were certain questions that were basically skill intensive, memory intensive, rather than like it is dependent upon the interpretation as to how you know what is the composition of the bench, and how did you approach and attempt these questions?
I think, to be very honest, I think the answer to bench strength judgments are purely on luck. I think there's no definite answer that it is not possible for any aspirant to read judgments with bench quorum. You can read maximum of constitution bench judgments or of any important judgments, let's say the sedition law, etc. But this time what was asked was the Gurmeet Singh order.
Yeah.
You don't expect a candidate to know a judgment on Gurmeet Singh, but
Hmm.
unfortunately I had read on the same day Sadhbir Singh's judgment was delivered, and I knew that Justice N.V. Ramanna and Justice Aniruddha Bose were part of it. So I had to take that gamble, and I went with the option of Justice Aniruddha Bose, Justice Suryakant, and Justice N.V. Ramanna. And fortunately, it worked out. But just because for this one or two questions, I don't think candidates or aspirants should make a list of cases of all the 100, 150 cases along with bench forum. I think that would be completely futile.
Okay.
At the end of the day, no one is will be scoring 100% in this examination. So I think if at all you want to read the bench quorum, read it for important constitution bench judgments. If any dissenting opinion, read the dissenting opinion and the name of the judge. I think that would be, I think, whole rather than
Whole
every,
rather than.
yeah.
Achha, my next question would be like, while you were preparing, Abhishek, so what were the things that you find out were the pitfalls or the shortcomings in your own preparation?
Yeah, I think multiple things. I think firstly is to, there are doubts, I think, which every aspirant face, that irrespective of how much you prepare, till the day of examination, you feel that it's incomplete. And I had that until I had the paper, and I knew that because you don't know what is going to be asked, whether they are asking something on 2017, 18, 19, 20. No one has a iota of doubt until the question paper is being distributed. So I think that part, I think, is the most biggest conundrum, and which affects the confidence of every individual. And because, so I think the best way is to just make sure that you're calm couple of days before the examination, not read anything new since the last couple of weeks before the examination. Just revise and have faith in the process which you have followed, the important judgment, important provisions you have followed, and not panic during the examination, and be calm and attempt the paper. I think that is the most important uh, drawback which I had. And to cure this drawback, you have to attempt mocks. It's not just that you are giving or you are attempting, you are studying well, you know judgment, that you won't practice mocks. I'm to be very honest, even I used to complete my mock papers before the scheduled time in the mocks which I had given, but in the actual day it was almost at the dead end of the paper. It was actual 2 hours of the paper. So I think the actual examination creates a lot of anxiety, lot of stress, and to balance all that, you just have to manage your time. So time management is the second biggest crucial aspect in this preparation, and that can only be cured by having the skills of reading fast reading skills, reading the questions, then looking for the important parts in the passages. I think those are few important things, and your preparation with proper few mocks, quality mocks, and that would be the holistic preparation.
Achha. So Abhishek, like you were talking about quality marks and everything else. So how do you think like us Sambhav Law and the team of Sambhav Law, how did you help? How did we help in your preparation?
Yeah, I think all the mocks which I attempted were had covered, I think, most of the areas of the law which even the CLAT consortium doesn't give much focus to. So all the minor subjects with reference to the NDPS Act, the SCST Atrocities Act, the Negotiable Instruments Act, the Arbitration Act, the Insolvency Bankruptcy Act, all these minor subjects were also given due emphasis by Sambhav Law and its team, and they tried more than their best to make sure that the candidates, even if they're not aware with the judgment, they can go back, read and revise the judgment and help in their preparation. So I think the one important thing which the mocks really helped me here was that it gives an idea extensively even on the minor subjects. And as far as for the major subject, as I said earlier, I think your preparation has to be a blend of both judgment and statutes, and I think the mocks were designed like that. So any judgment or any mocks based on criminal law had questions from judgment as well as the statute. So I think it, as I said, that it helps a lot, and I think there were quite a few of questions such as 167 CRPC, police and judicial custody this year. I think these were all asked in the mock which you had provided us. So I think the best objective is to make sure that you attempt the mocks and not be affected with what marks you're getting.
Yeah.
The marks are just at the end of, nothing matters. Just make sure that you prepare well, and I think the mocks were very well designed, including both from international law to minor subject to major subjects, covering various statutes and judgments to give holistic preparation. And it did not only cover from 2019 or 20, it asked questions from 2017, 2018, from various aspects of law. So I think the mock series as a whole was a complete package in itself, which is a boost in the final stages of the preparation.
Oh, thank you very much. Thank you very much for the kind words. So, Abhishek, my last question. In your honest opinion, is it like what is the approach? Is it feasible to prepare for this sort of exam in just the last 1 month?
I think that would, if you ask me that question, I wouldn't take the gamble to attempt it in the last 1 month, because I prepared for this 6 7 months, and I still was worried about this examination till 2 p.m. on the 19th of June. So I think that is a conundrum which everyone will have. So I think the best approach is to start early. I think at least give final year, substantial part of final years for the students who are in their final year, and at least give at least 6 months, because this requires time. This is not a 1 day or a 2 day game. This requires you to be aware with your judgments, your concepts, your time management. So in a 1 month you may cover judgments, you may cover statutes, but you might not be able to cover time management. So to cover everything holistically, I think it is better that everyone starts at least 5 to 6 months prior to the examination for guaranteed results.
Okay. So thank you very much, Abhishek. I congratulate you once again for this achievement, and
Thank
thank
you.
you so much for giving your insight as to how the preparation has to be done, and like the future aspirants who are watching this video might also find this very, very helpful. Thank you very much for your time. Thank you very
Thank
much,
you, sir.
Abhishek.
Thank you.